When you file a patent, the deal is supposed to be simple. You disclose how your invention works, and in exchange, the government grants you a temporary monopoly. It's a public registry of human progress. But that is only half the story. Behind the scenes, the U.S. Patent and Trademark Office operates as one of the most powerful intelligence checkpoints in the federal government. Under the Invention Secrecy Act, the Commissioner of Patents is legally authorized to freeze an application. If a defense agency flags an idea, the Commissioner shall order that the invention be kept secret and shall withhold the publication. This authority isn't restricted to classified military contracts or government-funded research facilities. This document from the Santa Clara Law Review shows that historically, roughly 15% of all secrecy orders are issued on patent applications originating from domestic sources for privately funded inventions. We are going to map exactly how a private invention gets trapped in this administrative machinery and examine how intelligence agencies utilized this pipeline against civilian mathematicians in the 1970s. The U.S. patent system maintains a parallel, classified framework that can unilaterally gag civilian inventors before the public ever learns their technology exists. Let's start at the beginning of the pipeline. An independent inventor files a patent application for a new technology. The government has no prior property interest, no contract, and no funding tied to this work. Before this application reaches a standard examiner, it enters an initial screening phase. The USPTO's internal security group 220 reviews incoming filings for sensitive subject matter. Routine filings pass through, but flagged technologies diverge down a restricted security review pipeline. The legal standard to freeze a patent depends entirely on who owns it. If the government holds a property interest in the invention, the threshold is extremely low. The reviewing agency only has to declare that disclosure might be detrimental to national security. For purely civilian technology, the Invention Secrecy Act sets a higher statutory bar. The reviewing agency must determine that public disclosure would be detrimental to national security. The USPTO routes these flagged civilian applications securely to defense agencies or the Armed Services Patent Advisory Board. If military and intelligence reviewers confirm the invention meets the would be detrimental standard, they send a formal recommendation back to the Commissioner of Patents. At this point, the Commissioner has no discretion. The statute dictates they are legally compelled to issue a secrecy order. This pipeline effectively grants military and intelligence bureaucracies a silent veto over private commercialization, relying entirely on internal, classified threat assessments. When a secrecy order is issued, the USPTO continues its examination to determine if the idea is patentable. However, if the application is approved, it is suspended at the point of allowance. It will not be published, and no patent will be granted. The severity of the restriction depends on the type of order issued. A Type 1 order applies to unclassified technology subject to export controls, permitting foreign filings only in allied nations with reciprocal security agreements. A Type 2 order applies when the application contains classifiable data, and the inventor already operates under a Department of Defense security agreement. Then there is the Type 3 order. This is a general secrecy directive applied to purely civilian inventions, where there is no prior security framework or government contract in place. A Type 3 order acts as an absolute gag rule. The inventor is prohibited from foreign filing, commercializing, publishing, or even discussing their own research with anyone not already aware of it. Statutorily, a peacetime secrecy order lasts for 1 year. In practice, defense agencies routinely renew them year after year, indefinitely. The consequences for violating this order are severe. Unauthorized disclosure can result in the abandonment of the patent, a $10,000 fine, and up to 2 years in federal prison. By executing this order, the state transforms a private tool for economic advancement into a classified asset, utilizing administrative law to enforce silence on private citizens. In the 1970s, cryptography started shifting from an exclusive military domain into a field of civilian academic research. This democratization of encryption created immediate institutional friction between independent civilian mathematicians and the National Security Agency. The prime historical test of the Type 3 secrecy pipeline occurred in 1978, involving a computer science professor named George DeVita. This diagram illustrates the basis of DeVita's invention, a stream cipher key generator built on a linear feedback shift register coupled with a nonlinear feedback circuit. His research was funded entirely by the National Science Foundation and designed to safeguard standard computer data. When DeVita filed for a patent, the NSA intervened. As this text shows, the government actively interfered in civilian cryptography by issuing secrecy orders on patent applications for privately funded inventions. The state used the patent pipeline to classify purely academic mathematics. The order placed a severe chilling effect on DeVita. He was now legally barred from lecturing to his university students, publishing academic papers, or discussing his own mathematical concepts with colleagues. That same year, a civilian inventor named Karlin Nikolai faced a similar restriction over a voice scrambling device called the Phasorphone. Nikolai's device didn't rely on classified government data. It was built entirely on well-known, public-domain, spread-spectrum technologies. Internal reviews from the NSA's own research divisions actually advised against restricting the Phasorphone, precisely because the underlying technology was already public. Despite that internal assessment, NSA Director Bobby Inman overrode his own researchers. He utilized the elasticity of the would-be detrimental standard to force a secrecy order anyway. Both cases triggered intense media and academic backlash regarding First Amendment rights, academic freedom, and prior restraint. Under immense public pressure, the government ultimately rescinded both orders. These historical cases expose how intelligence agencies can stretch statutory thresholds to suppress civilian research, prioritizing an asymmetric state advantage over public disclosure. The Invention Secrecy Act forces a confrontation between the core patent bargain and the imperatives of state power. The constitutional purpose of the patent system is to incentivize the public disclosure of new technologies to enrich the public domain. The Secrecy Act inverts this mechanism. It ensures that highly disruptive civilian technologies can be legally sequestered in the dark. This system is not a Cold War relic. Today, thousands of active secrecy orders remain in effect. While the statute strictly requires that disclosure would cause harm, the cryptography cases demonstrate how easily that threshold bends to fit the bureaucratic reality of intelligence agencies. Once the administrative machinery of 35 U.S.C. Section 18.1 is engaged, an invention is trapped in a bureaucratic limbo, regardless of who invented it. The USPTO operates as a critical, shadowy filter, ensuring that civilian innovation never outpaces the state.